Objection, Your Honor. Hearsay. We've all heard that line in movies, right? It's that magic phrase that just shuts a witness down. But what does it actually mean? Well, today, we're going to pull back the curtain on one of the most misunderstood rules in the legal world, the law of hearsay.
Okay, so let's start with something super simple, something that happens every day. Imagine your friend shoots you a text that says, "Hey, my coworker just said it's definitely going to rain tomorrow." It's classic secondhand info. You didn't hear it from the actual source, the weather person.
So what do you do? Do you just grab your umbrella without giving it a second thought? Maybe, but you probably wouldn't bet your house on it, right? Because you can't ask that coworker how sure they are, or if maybe they just glanced at a headline. And that right there, that whole question of reliability is the absolute core of the hearsay problem in a court of law.
So let's make this official. What does the law actually say hearsay is?
Okay, here it is, the official definition from the Civil Evidence Act of 1995. It's got two key ingredients. First, it's an out-of-court statement. So, anything said, written, even a gesture that happens outside of the trial we're in right now. Second, and this is the crucial part, it's being used to prove that the statement itself is true. So, going back to our rain example, using that text message to prove that it is going to rain tomorrow, well, that's hearsay.
Now, for a very, very long time, the courts had a really simple, really blunt way of dealing with this stuff. I want you to picture a very, very strict bouncer at the courtroom door.
And the rule was crystal clear. Hearsay evidence was not allowed in, period. The default setting was just to shut it down, keep it out of the trial completely. The legal system was just deeply, deeply suspicious of it, and, for some pretty good reasons.
This quote from a famous case back in 1952 just nails it. Lord Normand points out these huge problems. The person who actually said the thing wasn't under oath, you can't cross-examine them to poke holes in their story, and the jury can't even look them in the eye to decide if they're being truthful.
So let's just break that down. The oath, it forces a witness to take things seriously. And cross-examination, that is the ultimate tool for getting to the truth. And a witness's demeanor, how they act, if they look shifty, that tells a jury so much. Hearsay just strips all of that away, and you're left with this untestable secondhand story.
But here's the twist. What happens when a rule that's designed to protect the truth actually becomes a roadblock to justice? Let's look at a couple of cases where this super rigid rule caused some massive, massive problems.
Okay, get a load of this tragic case, Sparks versus R. A little girl described her attacker to her mother. Now that description pointed to someone other than the man who was on trial. But because the little girl didn't testify in court herself, her mom wasn't allowed to repeat what she said. It was just thrown out as inadmissible hearsay. Just think about that. Potentially crucial evidence that could have shown a man was innocent was completely blocked from the trial.
And this wasn't a one-off thing. The same problem popped up in R versus Turner. In this case, somebody else had actually confessed to the crime. But because that confession happened outside the courtroom, it was blocked. It was hearsay. The rule that was supposed to ensure reliability was now stopping the court from hearing a direct confession that could have set an innocent person free. It's just wild.
So these cases created a huge problem. I mean, if the main goal of a trial is to find out what really happened, how can you possibly justify a rule that actively blocks evidence that might prove someone's innocence? Clearly, something had to give.
And oh boy, did it ever change. The law in the UK went through this huge transformation that basically reshaped the entire way we think about hearsay evidence. It was a legal revolution.
And this was the year, 2003. This was the turning point. The Criminal Justice Act was passed, and it brought in a brand new, way more modern, and much more flexible way of dealing with hearsay.
So remember, under the old system, the starting point was always no. The courtroom door was just slammed shut to hearsay, and it could only sneak in through a few, very narrow, very specific exceptions. The 2003 Act completely flipped the script. Now the starting point is, let's consider it. The door is open, and the question is now, is there a good reason to let this evidence in? It's a massive shift in thinking.
So what does this new system actually look like? Well, instead of that strict no, the law now gives us these specific pathways or gateways that hearsay evidence might be able to pass through to get into a criminal trial.
And here are the four main gateways. Hearsay can get in if another law allows it, if it fits an old common law rule that they decided to keep, or, pretty simply, if everyone in the case just agrees to it. But it's that fourth one that is the real game changer, the interests of justice gateway. This thing acts like a safety valve. It gives a judge the power to let hearsay in if they think it's the fair and right thing to do, even if no other rule fits. This is how the court can stop the kind of injustices we saw in those old cases.
Now, let's zoom in on one of the most important new rules. What happens when the person who made the original statement just physically can't be in court to give their evidence? The old system really struggled with this, but the new law gives us a clear path forward.
And this is where the law gets really practical. Section 116 lays out these 5 specific situations. If a witness can't be there because they've passed away, are medically unfit, are outside the UK, can't be found, or they're in fear, their previous statements can now potentially be used as evidence. It's a really pragmatic solution to a very real problem.
So, there you have it. The law of hearsay has gone from being this rigid brick wall to a series of gateways. Now, this flexibility lets courts hear more evidence, and hopefully that prevents the kinds of terrible outcomes we saw in the past. But it also puts a ton of pressure on judges to really weigh the reliability of that evidence. And so the ultimate question is still out there. Does this new, more complicated system actually lead to a fairer result? Well, that's a debate that is still happening in courtrooms every single day.